The case is now being recorded. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth. Draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning and welcome to the Appeals Court. I'm Chief Justice Mark Green. With me on the panel for all 6 cases we will hear on our list this morning are Justice Kenneth Desmond Jr. and Justice Christopher Hodgens. The first 2 cases we will hear using our Zoom video conference platform with a simultaneous live stream to YouTube. As you can see, we are having some technical difficulties with Justice Hodgens' video feed, but we will proceed with 2 of the 3 panel members on screen and Justice Hodgens participating by audio. The first of the 2 cases we are hearing by video conference is case number 2022 P986, the Commonwealth versus Julius JUUKO. Attorney Epstein Santoyo, you may proceed.
Thank you, and may it please the court. This case has 2 main issues. The first issue, I think the court would prefer hearing about first, is a waiver and estoppel, whether the defendant is stopped or whether he's waived his ability to present his case on ineffective assistance of counsel. The second issue is ineffective assistance of counsel pursuant to Commonwealth v. Sylvain, Commonwealth v. Sylvain and Padilla v. Kentucky. With respect to waiver, I understand full-heartedly that the purpose of waiver under Rule 30 is to avoid any unnecessary litigation that creates any delay or that creates any relitigation of issues. We want to be judicially economical with it. The Commonwealth presents cases having to do with waiver and whether a defendant is essentially stopped, and I'm going to use a stopped and waiver in the same argument because I think they're very similar here, and I think it would be economical to do so. All of these cases that are presented by the Commonwealth have to do with a defendant that has had an opportunity to present his case before an appellate board. There's been review of the determination of a motion for new trial or any issues related to a motion for new trial in every one of these cases.
My understanding is that there was a notice of appeal filed, but the record was never assembled on that appeal, and that's the reason the case did not proceed on appeal. Is that correct?
That's correct, Your Honor.
And that was through no fault of the defendant.
That's correct, Your Honor.
All right, why don't we proceed and we can come back and talk more about estoppel or waiver if we have time. We can also talk more about ineffective assistance on first prong if we have time. But I'd like to hear what you have to say about the second prong, prejudice and specifically special circumstances, because it seems to me, speaking for myself at least, that is the most significant hurdle that you need to overcome here.
Yes. So with respect to special circumstances, the case on point that I'd like to direct the court's attention to is Commonwealth v. Labarenko, Commonwealth v. Henry, and Commonwealth v. Baltazar. All those cases deal with special circumstances, and special circumstances in the context of ineffective assistance of counsel has to do with the facts and circumstances that are attendant at the time of the defendant's plea. In this case, when the defendant pled to a quaff for RMV fraud, he was a legal permanent resident. He had children in the United States that were minors. He had a job. He was pursuing higher education. He had been in the country for several years. It wasn't a recent arrival.
Yeah, unlike some of the cases that have found special circumstances where a defendant emigrated to the United States at a very young age, had no meaningful connections in their home country. The home country was war-torn. This is a situation where not only did he have significant ties, but in fact, the immigration consequences that he now faces were occasioned by his travel back to his country to attend to ongoing business there.
That's right. And the fact that he had connections to his home country, I don't think detract from the fact that he placed such special circumstances on staying in the United States.
He was advised by his immigration counsel not to travel back to his home country. Is that correct?
After his plea,
Yes.
plea.
But he went nonetheless.
Correct.
Before he
Your
went.
Honor. And I think it speaks to the fact that he placed such an import on the fact that he had to travel to attend to important family business. Otherwise, he'd be living in, what some immigrants here in the United States call a golden cage. It's wonderful to live in this country, but there is a constitutional right for every person to travel to their country or travel freely in and out of the United States. It's one of the benefits bestowed upon legal permanent residents in the United States.
Sure.
And he was.
But what are we to take from that, though? I mean, if he was going to travel in the face of the advice of the immigration counsel, what would lead us to believe that he wouldn't have traveled in the face of the advice from his plea counsel?
So I think if we look at things in retrospect, Your Honor, I think we get in trouble because the whole point of him making that decision, we weren't there for him to have seen whether he made that calculus. He was deprived of that ability to make that calculus at the time of his plea. And the case law is very clear that he needs to be informed of whether there are going to be any consequences for him to make that calculus in the first instance.
Excuse me, Attorney Epstein Centauri. I'm having a little bit of trouble cutting in with my question, but I understand that he had reasons to want to travel back and forth freely. But there's a second piece, because special circumstances bear on whether it would have been rational to roll the dice and go to trial on these charges. And on that question, he would likely have faced the same consequences had he gone to trial. The case against him was really quite strong. And what he got was a very, very favorable disposition. So, there are some circumstances where even against almost impossible odds, the consequences of being deported are so severe that one could imagine a defendant being so desperate they will exhaust even seemingly hopeless opportunities. But in this case, what is the argument that it would have been rational for him to have issued the plea and gone to trial?
The mere fact that he would have the mere fact that the case against him, had he gone to trial, let me put it this way, excuse me, I'm sorry. His plea deal foreclosed any possibility that he'd have any chance whatsoever of. Sorry.
What was his plausible defense had he gone to trial?
So that's a great question, Your Honor. Had he gone to trial, I think he would have had a very difficult case against him. And in my brief, one of the arguments that I make with respect to whether there could have been a different plea bargain struck in by plea counsel at that time, I think is another reason why I think there was ineffective assistance to counsel. Not to pivot on Your Honor's point, but I think if plea counsel at that time had advocated for Mr. JUUKO from the very beginning and spoken to the judge, who asked very clearly why she should give him any sort of plea deal or what the justification was for any other plea deal, plea counsel does not bring up at all whatsoever the fact that he is an immigrant. Doesn't bring up any of his history other than that he wants to avoid a felonious charge.
Let me then, I take from your response to my question that you really have no plausible defense that you can point to, and instead you are arguing, albeit fairly obliquely, that a alternative plea disposition could have been reached that would have avoided the immigration consequences he now faces. But the record as viewed by the motion judge, and I have to say, as it appears to me, does not establish any identifiable alternative plea that would have been available. So it's fine to talk about that as an abstract hypothetical, but I don't see it on this record.
You know, well, I think it's difficult, Your Honor, to. I understand the court's position on that.
Did he in fact avoid the felony?
I didn't quite hear that.
I'm sorry, go ahead, Chief.
I said it's also the defendant's burden, but Judge Desmond, why don't you ask your question?
Did he in fact avoid the felony on the plea?
He did.
Okay, so he put a lot of weight on that and he got that, right?
He got that, but only because he wasn't informed as to what the other consequences would have been to his plea at the time.
Judge Broadbent noted that he had pled guilty to a number of OUI offenses, which had some serious consequences with respect to his traveling, and yet he still elected to plead guilty. What, if anything, should we take of that?
So OUI offenses don't have any inadmissibility or deportability consequences whatsoever. The only consequences attendant with OUI convictions or quaffs are a delay in citizenship eligibility. You have to have 5 years of good moral character, and an OUI stops the clock on good moral character for purposes of applying for citizenship. But there are no other attendant consequences for an OUI conviction otherwise.
So what is the alternative plea that you suggest could have been reached that would have avoided immigration consequences for this defendant?
Pretrial probation, deferred adjudication that has to do that avoids an admission to sufficient facts. So I think pretrial probation here would have been an alternative, especially in the context where he is, according to the record, he's applying for a job at a local CVS with an ID that's fake. He's not driving with it. He's not using it. All he's done here is try to get a second job because he couldn't otherwise get a job because of his status at that time. And so it's.
Let me just ask you a question, if you can hear me.
Yes.
The Commonwealth was recommending a guilty. So it seems to me it's kind of difficult to suggest that we're going to go from that to some sort of a disposition that just results in pretrial probation. I mean, how would that be achieved?
Through a request for pretrial probation. The Commonwealth had no idea what was going on with his immigration status at the time, had no idea what was going on with his family, how important it was for him to stay in the country and to be able to travel freely. The Commonwealth had none of this information, and it had none of this information because plea counsel at that time presented none of it, and plea counsel presented none of it because plea counsel didn't do any investigation as to the history of his own client.
But the government knew that he had been convicted of several prior motor vehicle related offenses, OUI, and here is another RMV or motor vehicle related offense, and you think that they would go backwards and give him pretrial probation?
I think it would be different.
Given his criminal record.
I do, and I think it would be different because he wasn't driving, he wasn't attempting to drive, he was trying to use this identification for purposes of getting a job, which is very different from him driving in violation of his previous suspensions or his OUIs.
But in all fairness, that belief, that suggestion rests entirely on speculation. There is nothing nothing from the Commonwealth, nothing from the judge, nothing from any source that suggests that an alternative plea of the sort that you described would have been acceptable or available.
Yes, it is speculation, but only because we're at this point now where we can't really go back in time to see what could have happened at that time when he made this plea, which was again uninformed.
We know that the judge didn't accept your recommendation, right? Or the plea recommendation. They wanted to quaff with 1 year, and she didn't accept that, right?
I'm sorry, Your Honor.
The judge didn't accept the offer of the defendant at the plea. They were disparate pleas. The government wanted a guilty and probation, and I believe that the defendant wanted a cloth with 1 year probation, and that was rejected for a more serious sentence, right? You got cloth with 18 months.
That's right. The defendant, that's correct. The defendant did get a more serious, but again, the judge at that time had no other information and no advocacy from the part of plea counsel with respect to why the sentence should be any different than what she gave at that time.
So your position is there was no argument made that judge, he was just using it to get a job and he was really just trying to get work to be able to support his family. You're saying that was not represented to the court? Correct.
None of that, or the fact that he had a green card. He really cared about keeping that. This is more important to him than getting a felonious charge. He's in school. He's struggling because he's in school. He's in higher education. He's working for the government, and he's just trying to get ahead. This is why he did what he did, for his family and for himself.
I'll leave it there, and just to prove that in fact we are rusty on Zoom, the red is not flashing, but it is unmistakably red. So we will hear from the Commonwealth.
Good morning. May it please the court, Kristen Jang for the Commonwealth. And I'm happy to jump to whatever issue the panel would like to hear on. Most of my brother's argument focused on prejudice. I'm happy to start there, if that pleases the court.
Because it seems to me that if we may end there, and if we don't, then we can work backwards.
Okay, sounds great. So I'm happy to start with the estoppel issue.
Let's start with prejudice.
Okay, we can start with prejudice. So I think my brother's biggest problem in this case is really the overwhelming evidence against him, that the defendant.
You heard that he had no significant response to the strength of the case. He was suggesting simply that despite that evidence and the likelihood of a finding of guilt had he gone to trial, that a plea disposition would have been available if pursued, would have avoided deportation or immigration consequences. Why don't you address that?
Sure. So there is no evidence that the Commonwealth would have been amenable to such a disposition, or two, that the court would have accepted it. So I do want to point to the transcript of the change of plea hearing. I'm on page 6 of that transcript, and defense counsel at the time represented to the court that, it was a terrible idea what he had done. It was a suggestion of a friend of his. He was trying to obtain a second job so he can continue to go to school and provide for his family. He does have 2 children. So the court and the Commonwealth were well aware of why he committed this crime, his circumstances at the time. The only thing that admittedly it doesn't appear that the court was aware of was the particular effect that this disposition in this case would have had on his ability to travel after this point. I don't think that there's no evidence that would have been enough for the Commonwealth to agree to some sort of pretrial probation disposition, or that the court would have accepted it.
In fairness, that is something of a structural challenge for any defendant in these circumstances, is it not?
Can you repeat the question? I'm sorry.
I said that is something of a structural challenge for any defendant in these circumstances, because there really is, how should a defendant marshal evidence to meet that burden?
Correct. To meet the burden of
an alternative plea disposition having been available after the fact.
That's true, but if there was perhaps less evidence against the defendant at that time, if it was, if there were the evidence against the defendant were less substantial, that would have been, that would have gone towards the defendant's case that some sort of different plea than what was entered would have been available. In this case, it was so clear that he committed the crime that, that really goes against him in this case in particular.
So you concede that he should have gotten better advice. Do you concede that point?
I concede that the case law is pretty clear that it's not sufficient to just give the general green sheet warnings. But at the same time, in this case,
And that's what happened here, right? He gave them
that is what happened here.
the green sheet warnings and told them, go see an immigration counsel. And
That is
been
what
held
happened
not to be-
here.
And that's been held not to be enough, right?
That's been held to be not the best way to practice. That's been held to be not sufficient. It's not necessarily been held to be per se deficient performance under the first promise of Farian.
And I understand your argument here that the immigration consequences in this case were somewhat more nuanced than in the case where the plea disposition would result in automatic deportation. But counsel was aware that he was a legal permanent resident, not a citizen. Counsel was aware that he had separate immigration counsel.
Yes.
And at a minimum, it would have been prudent, if not obvious, that counsel should have advised him, if he didn't know the answer to the immigration consequences, to consult with his immigration counsel, right?
It would have been proven, but it's not clear that didn't happen here. He was clearly speaking to an immigration attorney at the same time that this case was happening. So, I mean, it's not clear that counsel in this case, in this criminal case, did not say, go speak to your immigration attorney about this.
The record to suggest that plea counsel advised him to speak to immigration counsel before accepting the plea.
There's no evidence that in this particular case that's what happened, but there is evidence that their general practice at the time was to advise clients to go speak to immigration attorneys if they have an issue. But you're correct that there's no evidence that in this case that's what happened. At the same time, in looking at deficient performance, there also has to be a proffer as to what the advice should have been and what the steps counsel would have had to go through to figure out what that advice should have been. And I think
So had counsel done some minimal research, would he have learned that this offense, RMV fraud, was a crime against moral turpitude?
yes, I believe, and I conceded that in my brief, I believe that research would have revealed that. The problem here is that for this particular defendant, that didn't make him deportable because he had been in the country for so long. So
his ability to travel freely was important to him because of his particular circumstances.
yes, I think it's clear from the record that it was important to him, and clearly he continued to travel despite the advice of his immigration attorney. So it was clearly important to him, but I think for counsel to figure out that he would have been subject to these limitations, I think it's one step too far to put that burden on defense counsel.
The immigration counsel was surely aware of that.
Yes, that's correct.
Had his plea counsel advised him to speak with his immigration counsel, that would have come to the fore despite whatever challenges might attend to an ordinary criminal attorney's ability to sort out all of those nuances.
Yeah, so if you take the defendant's affidavit as true, as to he got out of the plea hearing and then called his immigration attorneys relatively soon thereafter, and it was provided this advice that now he could not leave the country. So if that had been reversed and this plea had been negotiated, he talked to his immigration attorneys first, maybe we wouldn't be here today. Who knows? But I still don't think he's shown that it would have been a reasonable choice to proceed to trial on these facts, even given all this, even given how important it was to be able to travel. I don't think he's shown that.
Okay, so then we are back to the question of whether there was an alternative disposition available, and we're back at the challenge that it is almost impossible for a defendant in this circumstance to meet the requisite burden.
I understand, but in other cases, I do remember reading, and I apologize, I don't have the name at the tip of my tongue, but I do remember reading that there was evidence of defense counsel, attempting to negotiate, but maybe not bringing it back to the defendant. There was more evidence that, in looking through a defense counsel's file, you can definitely tell if, there's emails in the file, if there's letters in the file, whether there were efforts made to negotiate some sort of deal and what the Commonwealth's position may have been.
Well, yeah, but the absence of that dialogue is itself a product of the ignorance around the immigration consequences. You know, it is an open secret, I suppose, that that despite the specific facts of the case, in certain circumstances, the Commonwealth will extend leniency or mercy to a defendant who is facing strongest immigration consequences in a non-violent offense. And it is also, it happens from time to time that where the Commonwealth does not extend mercy, plea judges do. We simply can't know because it was never explored.
I agree with you, Your Honor, but that's also why we have this whole concept of special circumstances in the case law and looking at whatever weight the defendant might have placed on his ability to stay in this country. In this case, the special circumstances is just his inability to be able to travel back and forth to his home country. That is not, to me, as strong as a lot of the other cases we have in this area where the person was a refugee or the defendant may have come here when he was very, very young and has no ties to his home country, maybe doesn't even speak the language. That in those cases, to me, it would be more compelling for maybe the Commonwealth to consider an alternative disposition if they were aware of that, or maybe even the court to consider an alternative disposition. In this case, his ability to travel back and forth to his home country, it doesn't rise to that level to me.
In negotiating the plea, it was brought to the judge's attention that he was trying to avoid the felony, correct?
Yes,
They
that's correct.
discussed that with the court.
That is correct. Yes, that is correct, which could have other non-immigration effects on his ability to get a job,
And
etc.
the court listened to that and indeed adopted a sentence that allowed him to avoid the felony, right?
That's correct. Yeah, the Commonwealth was recommending a guilty finding in this case.
Okay. So we don't know what the court would have done had the other argument been made.
We don't know, but in my opinion, honestly, the fact that he was just trying to get a second job to support his family is more compelling than, well, if you give me this certain disposition, I'm going to be able to go back and forth to my home country for these reasons.
I mean, that's interesting, but really of no moment. Let me ask you this question. After the plea, did he travel in and out of the country without incident at least once?
Yes, that's correct, Your Honor. That's correct. And if there are no further questions, I'm happy to rest my brief, or I'm happy to reach some of these other issues raised, estoppel issues.
I also see that Justice Hodgens seems to have, we seem to have lost Justice Hodgens, so we'll have to look into that before our next hearing. With that, the case is submitted, and thank you both for your argument.
Thank you.